Madam Foreman, was the doctor negligent? Your Honor, the defendant was not negligent. That's it. Your case is over. Your case is finished. You lost your case. Why is it that only moments later your attorney jumps up out of his seat and yells out, "Your Honor, I object to this verdict"? You want to know why? You want to know why he does that and what it's called in law? Come join me for a moment as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, let's say you brought a lawsuit against your doctor. You claim that he was careless and that his carelessness was a cause of your injury. And you also claim that your injuries were significant and permanent. The doctor, on the other hand, said, "This is nonsense." Said, "I did nothing wrong. And even if I did something wrong, guess what, Mr. Patient? So did you. And even if I did something wrong and so did you, guess what? Nothing that I did caused or contributed to your injuries." And by the way, they will also say, "Hey, listen, if I did something wrong and so did you, patient, guess what? Your injuries really are not as bad as you claim them to be." So now the defense refuses to negotiate at any point during the course of your lawsuit. And now your case has to go to trial. A jury has to decide whether you are more likely right than wrong, that what you are claiming is true. You also need to know that in New York, we are required to have a medical expert confirm that there was carelessness, that the carelessness was a cause of your injury, and that your injury is significant or permanent. So now, even though you have medical experts who have testified, the defense has brought in their own experts to testify, creating a clear conflict. And the jury has to decide who they believe, who is more likely right than wrong. The jury ultimately reaches their decision. They've now spent a great deal of time analyzing your case. Your case has been on trial for more than 2 weeks. And now the jury has been deliberating for about 4 or 5 hours. They come out, they tell the judge they have reached a verdict. And now they are asked to read the first question. You see, their verdict is made up of a series of questions that they have to answer. In a medical malpractice case, many times, the very first question that the jury has to answer is, was the defendant negligent? Now, what does that mean? The defendant is the person you have sued. In this case, it would be the doctor. So was the doctor negligent? What's negligence? Well, in this case, it's professional carelessness, medical carelessness. Did the doctor violate the basic standards of medical care? So the jury has to determine, based upon the evidence, based upon the testimony, and now combine that with the judge's legal instructions on the law about what is the definition of negligence. It's really professional carelessness. Did he violate those basic standards of medical care? Our expert says, yes, he did, and then he explained why. The defense expert said, no, he didn't, and he explained why. And now the jury has come to the conclusion that the doctor whom you sued was not careless. And because of that, they will never even get to any of the other questions to evaluate. They will not get to the question of whether or not the wrongdoing was a cause of your injury, nor will they ever get to determine the amount of damages, how much money you would have been entitled to receive as compensation for all the harms and losses and injuries that you suffered. So now, moments after the jury comes back with their verdict, your attorney jumps up out of his seat, yells out, "Objection, Judge! I move to dismiss this verdict as being against the weight of the evidence." In law, there's a fancy Latin term that's used. It's called judgment non obstante verdicto. And we use initials, an acronym, JNOV, to describe that. Now, what does that really mean? It basically says, hey, judge, the jury just came back with a verdict. It is our belief that their verdict is not based upon the evidence, that for whatever reason they came up with something else that is clearly not based on the evidence. And therefore, we want you to throw out the jury's verdict. Now, you might be asking, can the judge do that? The answer is, yes, he can. If the judge determines that the jury verdict is so outrageous and unreasonable and impossible based upon the evidence that was given in this case, it is quite possible that he could throw out that jury's verdict, in which case he would send the case back down to be tried all over again from the very beginning. Is it possible that the judge will simply turn around and say, hey, I'm not deciding this issue. You want to take this up on appeal? Go right ahead. You're more than welcome to. Or another alternative may be, counselor, you disagree with the jury's verdict? Put your request on paper, support it with the evidence that was presented, show me that this verdict is not based upon the evidence, and also I now have to give time to the defense attorney to rebut your argument. Let's do that on papers, and I want everything back to me within 60 days. Based upon that decision, now the losing party can go ahead and decide whether or not to appeal that verdict or whether or not to appeal the judge's decision. So why do I share this with you? I share this with you just to give you an inside look at what happens in these civil lawsuits that go to trial involving medical malpractice cases, accident cases, and even wrongful death cases here in New York. You know, I recognize and I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.